Winner is Ilana Linder. She's actually a alumni member of the Adams chapter. So thank you for your membership and your continued service to PAD. Ilana is an associate with Fraternal Law Partners. She is a Cincinnati native who joined Manley Burke as an associate in 2018. Ilana and Fraternal Law Partner have been very big key resources for Phi Alpha Delta over the past couple years, from anything from contract review, disciplinary matters, policy review, the whole bit. So they have a whole team there, and Ilana has been helping us out a lot. So uh, it's my pleasure to introduce to you all someone that we know at the executive office, Ilana Linder. Ilana.
Thank you so much. It's a pleasure to be here. Of course, I do wish we could. Oh, I've been spotlighted. Okay. I do wish we could obviously be there in person, but the world is a crazy time right now. So this is the best we can do. And I really do appreciate you all being here. Whoever's the host, am I able to share my screen? Yes, I am. Perfect. So I prepared a presentation and I think it has a lot of information in it. Let's see here. Can you all see that? Yes, okay, so I'm gonna stop my video and put that over and then start this. I think it'd be best probably for me to just go through it since I'm not gonna be able to see the chat box. If you wanna type questions in there, that's great. And then I will try to address them at the end. But without any further ado, as Andrew mentioned, my name is Ilana Linder. I'm an attorney with Fraternal Law Partners, which is a division of the Manley Burke Law Firm in Cincinnati, Ohio. And the presentation I've put together for you is for you as a current member of PAD's board that's designed to kind of give you a general overview and just a better understanding of what's involved with being a board member. Some of you may recall a little bit of this from corporate law 101 back your first year of law school. So I apologize in advance if any of this is kind of a repeat, but let's at least refresh your memory here. And to give you, oops, hang on. Is it going to let me? There we go. I guess I just have to click. Okay. Here's a kind of a quick overview of what we'll be talking about today. First, I'll start with, okay, well, you're a board member. What exactly does that mean or what does that entail? Typically will refer to you as a fiduciary, and we'll get into the definition of what a fiduciary is. In line with that, we'll talk about what your fiduciary duties are. As you may remember, there's the three big ones: the duty of care, duty of loyalty, and duty of obedience, and we'll go through each of those. We'll quickly talk about some of the risks involved with being a board member, particularly of a nonprofit. And then finally, I'm just kind of, as Andrew mentioned, I've been helping PAD along with other professional fraternities lately. And so I've been asked to kind of just give you a quick overview of what some of the kind of big picture, most common issues that we're currently seeing come across our desks in the law firm right now, in terms of what you might want to kind of be on a heightened awareness of that may go wrong within the actual chapters. Okay, so now you are a board member. What are some of your new functions that you may be called upon to perform? As you can see here, I've broken this part up into kind of two sections: your main functions and then your ancillary functions. I'm going to start with the main ones, and this will be the bulk of today's presentation. But the most important one is that you are a fiduciary. You'll hear me use that phrase quite a bit today, and that term has meaning in a legal sense. You can think of the word fiduciary as the legal aspect of being a board member. And again, most of today's presentation will be talking about your fiduciary responsibilities, functions, duties, and so forth. Another important main function, though, is also oversight as a board member. Here, I'm talking more about thinking kind of big picture, higher level, long term, especially as you think about what PAD looks like well into the future, even after the time that your service as a board member has come to a conclusion. So how do we ensure that not only are we operating efficiently today, but that we continue to grow and succeed well into the future so it doesn't just die down once we are no longer board members? Moving over to the other column, this is not a comprehensive or exhaustive list by any means of kind of some of the different functions board members may be called upon. And these are really going to vary based on kind of the size and I guess the age of any organization. So newer organizations, your board's going to be more heavily involved with the startup operations, whereas if you have a more kind of mature, been around for a long time type of organization, the board members themselves usually can kind of defer more to the executive staff to handle the operations. But just to go through a couple of these, for example, the first one, you've likely been selected to be on the board because you bring some sort of particularized skill, knowledge, or experience to the board. in a non-legal fraternity, you can easily imagine that somebody may want to bring on a lawyer to be on the board, not to serve in the general counsel type of role, but more so to just have somebody like, hey, what do you think might be the potential legal ramifications if we make XYZ decision versus some other decision? So just kind of keep in mind that you were brought on for a reason. You bring a unique skill set to the board, and you should definitely utilize whatever you bring to the board that other board members might not have. Another function some boards obviously ask of their board members, and the next two kind of go together, fundraising and board contributions. You may be asked to go out into your community and do peer-to-peer fundraising, like, hey, I'm on the board, I've made a contribution, won't you join me in supporting this mutually beneficial cause, and so forth. I already mentioned operations. Again, that probably doesn't come up so much with PAD. You guys are pretty well established. But again, just thinking, it's all about oversight, thinking about the long term for recruitment as well. Going back to how do we bring in new board members that will carry us well into the future beyond our own term limits here. Again, there may be plenty of others. There definitely are others that I am not mentioning here, but they're going to vary based on an organization size, purpose, and whatever your kind of motivation or goal is at any given time. All right, so fiduciary, those of you who loved Black's Law Dictionary may find this kind of familiar. This is the definition from Black's Law Dictionary of the word fiduciary. You can see the part that I underlined there. It says a fiduciary is one who owes to another the duties of good faith, loyalty, due care, and disclosure. This tells us a little bit, but it really doesn't break it down into concrete terms. So hopefully what we're going to do next is go ahead and put that into fiduciary terms. Some people like cartoons because they help them understand a concept. Some people just want a break from a bunch of text on the screen. Whatever purpose it serves for you, there's just a quick little cartoon about fiduciaries. All right, but let's get into it now. So you're a fiduciary. What does that mean? As a fiduciary, you should always be making sure, first and foremost, that you are staying informed of what's going on. You need to have a general understanding of the inner workings of the organization. You need to kind of know what the organization's goals are, and at least generally speaking, how it operates. You also must use due care in all decision making. And I want to emphasize here that the phrase due care is very intentional. We're not saying that you must use all possible care available under the sun, but rather you must use good care, reasonable care. And you need to use that reasonable care in reaching conclusions on different and particular matters. And I'll get into that a little bit more later. You also have a responsibility as a fiduciary to stay objective. Here, we're going to get into this more under the duty of loyalty, but just keep in mind that as a board member, you're expected to promote and elevate the interests of whatever organization you are serving above all other interests, including your own personal interests. And of course, you must be responsible, honest, trustworthy, and efficient. Again, the organization obviously believed that they could trust you and that you would be in the position to be able to act in the best interest of PAD. So keep that in mind, that even if you end up making a quote unquote mistakes at some point, as long as you are always thinking with the mindset of how do we promote the best interests of PAD, you're probably going to be okay. And we'll get into this a little bit more here, but I know people see on my agenda when I say like risk of board service, it scares people a little bit. And I put it in there because of that concern. And I kind of want to let you know that it's going to be okay here. All right. So you're probably sitting there saying, this all makes sense. Of course, I should be loyal. Of course, I should be informed. Why do I need to sit through a whole presentation on a Saturday afternoon? And I want to make sure, because it's sometimes some of these things do seem very obvious, but there's some things that just kind of go right over your head that you don't even think about, but could be considered a breach of one of your duties. So I do want to go through all of these, and we're going to break them down. Again, it takes the general term fiduciary duty and breaks it down into these three separate duties. You've heard me mention these already, but we have duty of care, duty of loyalty, and duty of obedience. And I'm going to go through each of those, starting with duty of care. The duty of care really just comes down to, or what the essence of it is just a duty to exercise due diligence in board matters. Again, I want to emphasize that the phrase due diligence is intentional. It does not say that you must exercise all possible diligence under the sun in reaching every decision. Rather, you should be exercising judgment, and you do have some discretion to evaluate the magnitude or the severity of whatever issue is before the board. So once you kind of can first take that evaluation, okay, like, is this a really big issue, or is this kind of just like an everyday kind of minor thing? Then you can move on to determining how much deliberation and due diligence is required to resolve that issue. So for example, if the board is considering, let's say, entering into a contract that if things hit the fan, you have a $500 risk on the table, that decision is not going to require as much consideration. Don't get me wrong, you still have to consider it and give it due attention, but that type of $500 of risk decision is not going to require the same level of attention and consideration as something that carries, let's say, $10 million worth of risk. So there are differing degrees, and I think everybody that is in this organization, I'm assuming, is able to understand that there's a difference, but you still need to be exercising care with all decisions that you're making. The duty of care also entails the duty to give informed and prudent attention to organizational affairs. What this really means, and I'll get into this a little bit more concretely here in a minute, but what it really is saying is just you need to be keeping up with what's going on within the organization and making sure you have a general working knowledge of the operational aspect, again, the goals of the organization, the inner workings. Generally speaking, you don't need to be intimately involved with everything that's going on. You have a phenomenal executive staff with PAD. Okay, so I'm going to go through kind of some of the more concrete and specific ways in which you can kind of fulfill your duty of care. Obviously, you need to attend meetings. This may seem very simple and straightforward, but we do see it quite often that there are people who that are on the board and just want to be on the board for the sake of saying they're on the board, but they're not actually attending the meetings. And we get it. Things come up in life, especially with the world we live in, and you can't always control your own schedule. And so missing 1 or 2 meetings throughout your term as a board member probably is going to be just fine. But if you're consistently missing scheduled board meetings, then that person has no way of really kind of staying informed and up to date of what's going on, and therefore not fulfilling their fiduciary duties, particularly their duty of care. So if somebody finds, and it's perfectly okay, like I said, we understand, especially in today's day and age, that things come up, and if you're unable to devote the requisite amount of time to serve as a board member, it would be best to consider maybe taking some time off or resigning, because again, that's not acknowledging any sort of personal failure, but rather it's recognizing and you're seeing that you have a responsibility to promote the best interest of PAD. And if you're not able to perform that, then there's no way you could be promoting PAD's best interest. So it's not a personal failure, but it's recognizing that you owe a duty and you owe what is best to the organization. And if that means you stepping aside, then that means you stepping aside. Another way to fulfill your duty of care is prepare for the meetings. I'm on a board right now for a different organization where we're considering a contract to partner with another organization for services, a fee for service. And something that you do to prepare for the meeting is you review the drafted contract. You highlight, or for me, I like to print things off and annotate them, right in the margins, and you come with questions or you come with concerns. It doesn't mean you're always going to have a question or concern, but make sure you're reviewing whatever materials provided ahead of time so that when it's time for the meeting, you're able to sit down and have a productive and meaningful conversation to get things in place. During the board meetings, you should, of course, listen to any reports, especially sometimes the most common one here is kind of like the executive director reports. You may have committee meeting reports if you have different committees that kind of come back and give an executive report to the board. But you need to just kind of take it all in so you understand, again, what's going on within the organization as a whole. You don't need to know the intimate details of every single little part of that. But again, making sure you understand and ask questions if necessary during those meetings. Now, you're not expected to fully understand every possible thing that is presented in advance of a meeting or during the meeting, and that's fine. Again, the important part is that you're willing to stand up and say, hey, wait a second, I don't get this. Can we talk about it? Can someone explain this to me? Because one of the worst things you can do is just kind of rubber stamp or vote on something that's proposed when you have no idea what you're even voting on. So make sure you understand it before you're recorded as putting a vote, yay or nay, next to anything. You should also have a working familiarity with your governing documents. So things like your bylaws, your articles. Some organizations have specific rules and regulations. Again, you don't have to be an expert on any of these documents, but you should have at least a general idea of how the organization works from more of like a corporation or corporate perspective. All right. So one issue that comes up a decent amount is that of delegation. In other words, kind of as a board member, can I rely upon or can I somehow delegate my responsibilities to someone else? This comes up a lot, again, because a lot of board members are volunteers, and we recognize that you don't have endless amounts of time to devote exclusively to your service as a PAD board member. You definitely have lives outside of the organization, and the law does recognize that. So what you want to know here is that while a director is not permitted to delegate the entire duty of care, you do still have a duty as a board member to examine and consider everything and then make an informed decision based on the best interest of the organization. The law does allow you to rely on information or reports from others, but it is very specific about whose information or whose reports you are entitled to rely upon in making those decisions to still be protected. So specifically, as a board member, you are permitted, I have it there, to rely on information from one or more directors or officers or employees of the corporation. Again, just a minute ago, I mentioned that you have a duty to attend the meetings, and if the executive director or these other officers are giving reports, you should be listening to those reports and asking questions, but or whatever information is presented. But once those reports are understood, you are allowed to rely on those reports during the board meeting. Like the reports that are given during the board meeting. Likewise, you are permitted to rely on information, guidance, like advice obtained from either your legal counsel, and this gets a little tricky with a legal-based organization like PAD because everybody thinks that they're a knowledgeable attorney, and not to say that they aren't. But here, when I say legal counsel, I'm talking about so in some cases, it would be outside counsel like my law firm, or some organizations have a general counsel, but it's a designated kind of outside professional or that serves as the attorney essentially for the organization. You can rely on that person. You can also rely upon public accountants, especially when there are things, if there are significant implications or ramifications involving financial matters. Especially if you don't have any fellow board members who have a background, well, at least in this case, in the finance area. And then you're also allowed to rely upon the reports or information provided by a subcommittee in the larger group of board members. Okay, so before I move on here, again, just the takeaway here is that you cannot delegate the whole duty. You do still have to examine, consider, ask questions and everything, but you can rely upon or turn to others to help you make those decisions. So you don't necessarily need to go out and do all the research yourself. You don't need to have your own personal knowledge about finance or accounting mechanisms. You can rely on these reports, but at the end of the day, you must make sure you understand it enough to rely upon it. Okay, so that kind of helps you understand that you don't necessarily have to go at this alone. You, again, you can't delegate the responsibility to make informed decisions, but you don't have to be an expert on everything. The one caveat that I do want to make sure that you're aware of is that when you're relying upon the expertise of others, you have a duty not only to make sure that you understand it all, but to exercise due diligence to ensure that your so-called expert is actually an expert, that they are competent and knowledgeable in the area in which they are claiming to be a so-called expert. So you do kind of have to do a little bit of vetting or like maybe preliminary background research to make sure that your designated advisor, so to speak, is actually reliable and trustworthy. But once you've done that, you should be fine in relying upon that person's expertise. But if you're sitting in a board meeting, for example, and you're listening to a presentation that is being given by somebody who says, let's say they're a financial advisor, and they're making suggestions that just seem completely off the wall or just contrary to basic common sense, that should definitely be a red flag for you. So you should take a moment and say, wait a second, are we sure we should be trusting this person? Or maybe is there somebody else that would be better suited to guide us to make sure, again, we have a duty of care. We have all these fiduciary duties to promote the best interest of the organization. And you don't owe it to anybody. You may offend them by saying, hey, we don't necessarily trust you anymore, but you do need to kind of vet them. So again, just always be alert and make sure that the person or the people that you're trusting are reliable sources. But once you've vetted them and you feel confident as a board that they'll help you promote the organization's best interests, then you can certainly rely upon their expertise in fulfilling your duties. All right, so before I move on to the duty of loyalty, I just want to give you a quick review of what we talked about here under duty of care. The first thing is, of course, to remember that the duty of care is not the duty to be exactly right. It is the duty instead to act on an informed basis. So you're coming to the meetings prepared, you've read the material, you know what you do and do not know, you're ready to ask questions before making a decision. So the duty to act on an informed basis, and it's listed there in good faith and the honest belief that the action taken is in the best interest of the organization. Even, again, as I mentioned before, even if you make a mistake or you get something wrong as a board member that later proves out to have not come out the way that you anticipated, as long as you've fulfilled your duty of care by acting, again, on an informed basis, good faith, and honest belief, you're gonna, the decision that the board makes, again, even if it doesn't have the most desirable outcome, that decision will still kind of be respected and, so to speak, protected and upheld by the courts. The courts will generally defer to organizational decisions as long as they were made in good faith. All right, so let's move on to the second fiduciary duty, which is, again, is the duty of loyalty. Duty of loyalty is relatively straightforward, but it is still important, so I'm going to spend a little bit of time going through this. The duty of loyalty requires honesty, good faith, and fairness in all of your dealings as a board member. It requires the avoidance of undisclosed conflicts of interest, and we'll spend some more time talking about that here. But I want to make sure that it's clear that conflicts of interest in and of themselves are not necessarily, quote unquote, like inherently bad. Now, undisclosed conflicts of interest are bad, and we'll come back to that. But I do want to make it clear that there are bound to be conflicts of interest, and that is okay as long as you go through a proper process and procedure for handling them. And the duty of loyalty generally prohibits directors from using their position of trust or personal advantage at the expense of the organization. Again, this goes back to the whole idea that you should be putting the organization's interests above all other interests, including those of your own. And it really gets to the heart of what it means to be a fiduciary to say that. All right, so I want to give you an overview briefly of 3 of the most common forms or ways that we have seen board members breaching this particular duty, the duty of loyalty. Again, this list is not meant to be exhaustive. It's not meant to be an exhaustive list of all the ways in which you can breach your duty of loyalty, but these are kind of our hot ticket items that if there's going to be a breach of a duty of loyalty, we're probably going to see it in one of these 3 forms. So the first, as I've already alluded to, is the failure to disclose conflicts of interest. Again, conflicts of interest in and of themselves are not necessarily bad or evil, but you do have to disclose them, and your failure to properly disclose them could constitute a breach of this duty of loyalty. Another common breach that we're seeing, though not as frequently, but it is still there, and it is a big one, is the misuse of the corporation's proprietary information and opportunities. In your role as a board member, you're undoubtedly going to be given access to or provided a significant amount of corporate information, proprietary information that is not available to the general public. And you are expected to not use or trade on that information for your own personal benefit. If you do, you've likely violated your duty of loyalty. Again, the whole point is that you are elevating the interests of the organization above all other interests, including those of your own. So if you're using that information for your own personal gain that you obtain privately, then that's a no-no. Another common breach, and we don't see this one actually as much, but it is becoming a little bit more common today than in the past. And it is a big one when it happens, and that is misappropriation of corporate assets. So those are kind of the 3 big ones. Again, it's not an exhaustive list, but I want to kind of get you thinking about these, and we'll get into some of these a little bit more with some examples if I think we have enough time. Yeah, okay. So here's the kind of, these are the categories, the most common types of conflicts of interest. I'm not going to go into too much right here, but kind of it's not just a conflict of interest directly between you and the organization. It could extend to your family. It could involve your companies and so forth. All right, so let's talk about, again, I mentioned it's okay to have conflicts of interest, but you need to handle them properly. So let's talk about how an organization could actually and properly handle a conflict of interest as they arise and what to do when there is a conflict. First and foremost, every organization needs to have in place a written policy that explains what a conflict of interest is and how they are disclosed and how that is handled. I'm fairly certain that Pat is in compliance with this one, so that's not a concern. But it is also, you also need to make sure that you understand what's in that conflict of interest policy. It's one thing to have a policy; it's another thing to actually adhere to and implement your own policy. The next most important thing is the directors must disclose their conflicts of interest, ideally in writing. Depending then on, with regard to competitive bids there, depending on the size of any given contract and the availability of obtaining competing bids, we usually like to say to get at least 2 or 3 competing bids on any big item. But sometimes it's just not possible to do that. Again, it is advisable to and best to obtain multiple bids. And the reason behind that is to make sure that the services or goods that are being offered by any particular vendor or company, you're making sure that they're actually competitive both in price and quality, and that it would be a good deal for the organization and in the organization's best interest. Now, again, if the size of the contract is relatively small or so a minor matter, it might not make sense or even be feasible to obtain multiple bids, and that's okay. In that case, it would just be in the board's best interest to at least notate and document somewhere, preferably like in your minutes or something, just to say, here's what we decided. We decided we're not going to obtain multiple bids for this matter for these reasons. And then notate, we did consider this. We're not getting bids. We're going to go with this person. We think that they are able to meet our needs and that this is an appropriate offer. And this just kind of documenting all that just helps ensure that there's no question about whether your duty of loyalty was being honored. Any interested director should, we recommend, directly abstain from voting on any particular matter in which they have a conflict of interest. So just don't vote on something that you may have something to gain from. We also recommend, in addition to abstaining and staying out of the discussion, but not even having the potentially conflicted board member in the same room where the rest of the board members are discussing the proposed, let's say, a contract. Again, it's really just making sure that there's no kind of contamination of the proceedings by the conflicted person so that everything is done by the book and there's no questions later. And it is reported on the 990. I'm fairly certain that Pat is in compliance with that. Okay, so this is an example that I'm just going to go through quickly. So imagine that I own an interior design company, and let's say Pat is looking to hire an interior design company to come redesign the headquarters office or something. If I am on the board, I'm allowed on behalf of my interior design company to submit a bid for that job. That in and of itself is fine. But what you still have to go through the procedure, which again, step 1 is that I need to disclose it. I say to the rest of the board, hey, this is my company. I do have a conflict. I'm going to abstain from voting. Actually, I'm going to go outside in the hallway while you guys talk about this. And then the rest of the board has the right and the ability to then ideally obtain at least one other competitive bid to make sure that my company's proposal is reasonable. And then the rest of the board gets to deliberate. Again, it's fine to have a conflict of interest. It's also fine to still hire my company. At the end of the day, if the bid that my company submits to PAD is in the best interest of the organization, it is okay and actually acceptable to go ahead and accept my bid, as long as you, again, have documented that process. I've abstained, I've walked out, I've let you guys do the discussions, and you've come to the conclusion on your own as disinterested board members. Again, it's okay to have conflicts of interest. You just need to take some extra precautions to prevent you from breaching that duty of loyalty. Also, under the duty of loyalty, you have what is called the usurpation of a corporate opportunity. This arises when a director uses confidential or proprietary information that he or she obtains as a board member, like while serving as a board member for the organization, and then uses that information to the detriment of the organization. The whole point, again, remember, is to elevate the best interest of the organization, including above your own personal interest. So here, it can take different forms, but it really just comes down to using your privileged position to the detriment of the organization. I'll very quickly go through this example to show you kind of how the usurpation of a corporate opportunity could come up. And in this one, there was a board member, we'll call him Alex, okay? Alex owned a printing company, And it was a family business, and they were able to quickly print, let's say, different like brochures, posters, and stuff like that. Alex is serving on the board for an organization, and that organization was looking to hire a printing company to produce a bunch of organizational outreach materials for the organization. So the type of services that Alex's company provides. Let's say that the organization, just to simplify it, wanted to launch a capital campaign. So they want to have a company print a bunch of donor materials to send out to prospective donors. So Alex, keeping in mind he owns his own printing company, Alex's company originally does not submit a bid for this work. Instead, Alex just sits there, he keeps quiet, he does not disclose his potential conflict of interest to his fellow board members. And instead, Alex just keeps kind of actively participating in the board's review and consideration of Alex's company's competitors' bids. So competitors to Alex's company have submitted their bids to the organization for their consideration. Alex is sitting there quiet during the deliberations. In turn, Alex can then go back to his own printing company and use the information that he's gathered based on the discussions he's been privy to in the board meetings to create a favorable and separate bid to the organization for that work. Now, if Alex had disclosed at the beginning that he had a potential conflict of interest, and especially if Alex had abstained from participating in the review of those other competitors' bids, it probably would have been okay. The issue here is that he didn't, and instead he took that privileged position and the information he obtained from that position, which included, for example, what the prices that his competitors were offering to the organization. And he was able to see what his fellow board members liked or disliked about each of his competitors' bids. And he took all of that information and then tried to gain a benefit from it by being able to submit what he knew the board would likely accept as a bid from his own company. Now, again, there's no problem if the board actually decided to hire Alex's company after he abstained and they went through the due diligence and the proper review, which goes back to the duty of care. And it wouldn't be an issue if the board was aware of that conflict of interest and he abstained. But because he didn't, this becomes a big issue as a breach of duty of loyalty. Okay, I'm going to skip that example just for time. So also under the duty of loyalty, something that we don't see that often, but when it does happen, and it is quite large and quite a big deal, and that is misappropriation of assets. Again, historically, this has been pretty rare, but when we're starting to see a little bit more of it today, especially insurance companies are starting to become a little bit more aware of it, and it can become an issue because it could raise your insurance premiums, to say the least. But anyway, so misappropriations of assets, I don't think anybody would doubt that that is clearly a breach of the duty of loyalty. It goes without saying, but I do want to keep it on your radar just so that you're aware that that is a form of a breach of the duty of loyalty. What is much more common than theft or the misappropriation of assets is actually the misuse or improper use of assets. This usually happens inadvertently, and we don't necessarily mean to do it. So it just kind of happens. Usually these things are kind of smaller dollar ticket items. They're not going to necessarily be the high number, like millions of dollars of embezzlement or anything, but they're still important and something to keep an eye out for. Some of the most common forms that we see are listed here. So that salaries of your officers or executive directors, the use of cars or vehicles that are intended for organizational or corporate purpose, but you're maybe using them for your personal time. Same with office services. Plane tickets or like spousal travel. So let's say we were all going to Phoenix for this conference, and instead of me just going, I decide to bring along my boyfriend for the weekend. Again, if he wants to come, he can pay his own way, but you can't use the corporate assets to pay for spousal travel. Okay, I think the rest of that is pretty obvious. I'm not going to go through this too much, but it's a nice little depiction of kind of how fraud kind of ends up happening. You have the opportunity, the rationalization, and the pressure and motivation, and they all kind of combine to create this perfect storm, and that's where fraud usually occurs. All right. I'm going to skip. Okay, so this brings us to the third duty, which is duty of obedience. I'm going to go through this one pretty quickly. I think it is relatively self-explanatory, but it will highlight a few things about it. So it's exactly what it sounds like. It requires you as a board member to be obedient to the corporate purpose of the organization. you need to be complying with and obedient to not only the governing documents, such as your articles, your bylaws, but also all federal, state, and local laws. Here, you don't necessarily need to be an expert in everything. That's why you hire professionals like lawyers and accountants to know what the law is, particularly, especially when it comes to nonprofits and maintaining your nonprofit status, but just to be aware of this stuff. There are a few different ways that you can comply, or that you can ensure that you're complying with the duty of obedience. So from a programming aspect, we recommend that you always review your strategic plan and mission statement, and make sure that what you're doing, this kind of goes back to your conflict of interest policy, making sure that what's written in your mission and vision and all of your policies is actually what you're implementing. So making sure you're walking the talk, not just having policies that you don't actually adhere to. And we also recommend that at least every few years, maybe every 2 to 5 years, is a good time to be reviewing your governing documents and make sure that your organization is accomplishing whatever it's set out to do in your mission statement. How, in other words, asking, how are we making sure that the organization is still heading in the right direction, and that direction is indeed the intended direction? It's certainly possible, and we do see this a little bit, especially more so with newer nonprofits, but you'll see they'll start to engage in some activity with one goal in mind, and then they have to change their course either due to preference or due to necessity, and that's okay, but you want to make sure that whatever your written mission statement, goals, policies, whatever, you need to make sure they're consistent with your actual policies. Let's see here. You also want to make sure that the person who is supposed to be doing something is actually the person doing it. So, for example, if it's your policy that only your executive director is supposed to be signing checks or signing contracts on behalf of the organization, then you shouldn't also have your financial officer signing those contracts or checks as well. So again, just consistency in your operations to make sure they match your policies. Moving on here, I'm not going to go through I have a couple of examples, but unfortunately, this is a very real example that you may be confronted with as a board member. And this was a very clear example of a blatant violation of a board member's duty of obedience. Certainly, people are entitled to have their own opinions and beliefs about different things. And when those beliefs, I'm sure about the one I'm about to describe, doesn't necessarily directly impact your organization's operations. I don't expect it to, but it has come up recently, so I want to go through it. So in this example, you have somebody that's actively serving as a board member, and that board member openly asserts that he does not think that the organization should be, let's say, assisting minority groups, whether that's a racial minority or a LGBTQ plus individual, whatever it may be. They express a belief that there are certain types of people that just should not be allowed to join PAD. This type of statement is not only contrary to the law, you cannot discriminate, especially if you are a recognized tax-exempt organization. You do have to attest to the fact that you will not be engaging in discrimination on the basis of any protected characteristics, but it's also likely a statement that is contrary to the organization's own non-discrimination policy. So you can't actively and truly be serving the best interest of the organization if you actively express these sorts of beliefs and then try to have them carried out into practice. So hopefully that is not something you guys have to be confronting. I will kind of come back to this a little bit when I talk about some of the common issues we're seeing on campuses, but I haven't seen this so much with issues with actual board members, but it certainly could come up. Very quickly, what are some of the risks of serving on a board? I know a lot of this may sound a little bit scary or overwhelming, but really your risk is relatively small. As long as you're complying with those 3 duties, your duty of care, basically avoiding any conflicts of interest and not usurping corporate opportunities, and obeying the law, you're probably going to be fine. You've got to use good faith. You're doing a double check. You're making sure that whatever decisions you're making are in the best interest of the organization. You don't always have to be right. And I want to make sure that you leave this presentation knowing that this is not about being perfect. It's about going through a process and engaging in due care. It's making sure you have the appropriate level of attention and diligence that may be required. And there's certainly no guarantee that you're always going to get it right and that you'll make everybody happy. You're likely not going to make everybody happy with each decision you make. But if you truly believe, and you have a good reason to believe that your decisions are promoting the best interests of PAD, then there's very little risk involved. There usually will be some sort of formal indemnification of board members provided by the organization you are serving. So again, as long as you are following your duties to the best extent possible, the organization is most likely going to stand behind you as a board member and provide formal indemnification should anything ever go awry. And related to indemnification, usually a large organization like PAD has some form of insurance that would cover any action, but you're only going to be covered if you are complying with your fiduciary duties. If you are going rogue and doing whatever you want and not following your duties, you are not entitled to the protection. Okay, we got a couple minutes left here. I appreciate you guys kind of sticking it out with me. Andrew asked me to kind of go through some of the more common chapter or member issues our office is seeing lately, particularly with professional fraternities. There's of course always hazing and alcohol concerns with more of the social Greek fraternities and sororities. But within the professional fraternity world, these are the three that I would say these are kind of categorically the most common three issue types that I've seen. The first is social media. And this has been rampant ever since 2020 in particular. It seems to be dying down a little bit lately. It, of course, was a lot more prominent over the past, the summer with the Black Lives Matter movement, with the elections. It gets very contentious. Here, there's always a concern about, well, do students have a First Amendment right? Freedom of speech. Yes, they do have a freedom of speech in terms of like what a public university can or cannot do, but there is no First Amendment right as it relates to membership in a private organization. However, we do always caution organizations that even if speech is not protected, it might not be in the organization's best interest to discipline or sanction for that speech, because it could have other types of backlash, especially you don't want to end up on the front page of any newspaper or on the 5 o'clock news, so to speak. So to think about the kind of pros and cons of each decision, and these are the types of discussions that our office frequently has with executive staff from different professional fraternities and sororities. The next one is cooperation and university investigations. Here, and again, it's not a huge issue so much with professional organizations as it is with the more social ones. But what I see a lot that gets organizations and their members into the most trouble is that there's one set of charges, let's say hazing charges against the organization, but then once the university starts trying to meet with students and conduct an investigation, people start lying, they start falsifying, they start messing with documents or evidence. That is probably the worst thing that can be done, is to try to cover it up and be dishonest within the university's investigatory process. Cooperation is key, and universities are much less likely to impose additional sanctions or additional charges if there is clear and transparent cooperation. And lastly, leadership transitions. This kind of unfortunately plagues any college-based student organization, where each year they tend to get a new slate of leaders, and their record keeping or their transitions between leaders from one year to the next is not always the smoothest. A lot of organizations, nonprofit organizations, their chapters, one of the big things we see is maintaining the nonprofit status. I don't recall off the top of my head how PAD does it, but there's one sorority I can think of in particular that leaves it up to their chapters, individual chapters, to renew their to file the 990 each year. And if you don't file the 990, then after 3 years, you lose your tax exempt status and have to reapply for reinstatement. And the biggest reason that, or the greatest contributor to that, is just one, usually the treasurer not telling the incoming treasurer, hey, you need to do this. So then you have 3 years of treasurers not knowing that they're supposed to do anything, and all of a sudden you've lost your tax exempt status. So just kind of making sure that chapters have either some sort of like leadership transition manual or book, or that there are active discussions to try to go through and have a smooth transition. And with that, I know we only have a couple more minutes here. I'm going to stop sharing my screen. And if there are any questions, I know that was a lot of material. I appreciate you guys sticking it out with me. But if there are any questions, I'd be happy to take them at this time. Yes, Nicole.
Thank you so much for that presentation. I think appreciate all of the information you provided about the fiduciary duties that we had or have. We did talk a bit about that earlier as well, but I'm interested to see, from your standpoint as a lawyer and a law firm that represents fraternities and sororities regularly, what type of best practices might you be able to share with us as it pertains to social media? I know that's something that obviously, in the wake of many tragic events over the past 2 years, has been at the forefront of a lot of organizations, especially organizations that are based at a university level or law school level. As it stands now, our executive office runs our social media to ensure we're on brand and to ensure we're maintaining, keeping our membership informed of various things that are going on. But there was a point in time where we had a social media channel that was more open to membership. And so I'm interested to see your thoughts from a best practices standpoint on that.
Yeah, that's a great question. And even just yesterday, I got another email. Like I said, there's kind of been a lull, and then all of a sudden it seems to be picking back up. And this one was people going at it in the comment section on Instagram. I'm like, what's next? Like, where does this end? So to address kind of the second half of your comment first, I do think to the extent possible, it is best to have a central control over any messaging that's coming out of an organization. That gives you the ability to have full control. It also means that whenever PAD's name or logo is associated with something, it has kind of gone through some sort of vetting process. The issue becomes what to do when you have individual members or an individual chapter that decides to have their own social media page or decide to wear their letters in pictures that end up all over social media. There's not, and I can't remember, I do believe, but I could be wrong. I think PAD has a social media policy. If you don't already, you definitely want to get that updated. But the social media policy is a way to hold members and chapters a little bit more accountable. There's still going to be instances in which there are double secret Facebook groups that you don't know about. And then when those get out, like, people will take screenshots. And so I think communicating that people think that just because they have their social media accounts private, that nobody else can see it. And that's not true at all. Like I said, screenshots are rampant. And I've got this one woman, she's not even associated with any organization, but she just got into this fight over Little Caesars with another member, and it somehow turned into a racist comment. And now she's on this rampage she's emailed the university about this student. This is for another professional fraternity. She's emailed the university calling for his expulsion. She's emailed the national fraternity asking for him to be removed. At that point, the question becomes, what is the organization's responsibility? And I told that organization yesterday, I said, at this point, do not engage further, especially because this came up over a weekend. Sometimes it's best to let things die down a little bit. Now, there is the risk that if you don't take care of it, that they'll get even more frustrated and will try to do something else. But at the end of the day, the question is, has this person violated one of our policies, or has the chapter violated our policy? If not, you don't really have grounds to sanction them. Now, if you want to sanction them, you can make a colorable argument that this is conduct unbecoming of a brother. So you can go both ways, but we usually try to say, from an organizational standpoint, have a policy, adhere to that policy consistently, and try to stay out of the rest. Because the minute PAD takes a stance on something that it didn't even want to get involved with, then you're in it for the long haul, and it becomes more difficult to get out of it then. Any other questions? I know we're running over a little bit.
I have one question. I know I'm going to take a little liberty with my time. Sorry. The question is about school investigations. If we are, I know this never happens for us, just a joke. If we're notified of a complaint, however, the chapter or the people in the complaint have already opened a school investigation and they are handling it, what is our responsibility as PAD to do a mutual investigation with them, or do we do our own, or do we let them work with a partner with the university?
That's a great question. My initial response has always been, anything that PAD does internally is PAD privilege, and not to share it with the university. Now, and I maintain that. Now, we have seen increasingly lately universities pushing for, once they find out that the organization is doing their own internal investigation, they try to get those records. At the end of the day, there's no entitlement to those records unless there is some sort of contract in place, which is very rare, that says the national organization agrees to turn over any investigatory documents or findings to the university. What you may occasionally see, and again, this is kind of rare, it would be in the universities that some call them a Greek relationship agreement, just the relationship agreement, is as a requirement for recognition. The university may tell the chapter that if they do an internal disciplinary review, or there's conduct, then the chapter may have to turn something over. But from PAD national standpoint, if PAD decides to do its own investigation, it should be, in my opinion, separate. If PAD believes it would be in PAD's best interest to work with the university, that's a different discussion. But I would usually err on the side of not sharing documents, because the minute that they leave PAD, you can't really control who else gets them. And they can be used and twisted, unfortunately, in ways that you never intended. So now, if PAD discovers something through its own investigation that is of grave consequence, and I know that there was an incident with another fraternity where once internally the fraternity learned of a significant risk that a member posed to other members of the community, that's different. Then you probably should go to either the university, or in that case, we had to go to the police, actually, to bring it to the appropriate individual's attention to protect others. But if it's just a kind of internal policy consideration, like, hey, did this person engage in conduct unbecoming of a brother, or did they break one of our secret policies, that's different. And that's something that I think there's no reason to share with the university, because the universities, not so much with professional fraternities, but there are some universities that, quite frankly, seem to be trying to find any way to get rid of Greek organizations, unfortunately. So I would say don't give them any more than is necessary.
Perfect. Well, thank you again, Ilana. It was
No
great to
problem.
hear you speak in these these terms. So
Pleasure to be here. Thank you all.
yeah, and just so you know, if we do run into any issues, I generally, and I just don't feel right, I run it through Ilana just to see, as a gut check, to see where we are, and just to move forward. So I think we're all on the right page. So very, very thankful. Oh, Nicole.
Sorry, I had one quick question. I think this is a quick one. You mentioned that any organization should be reviewing their governing documents every 2 to 5 years. Who do you recommend should be conducting that review? Should it be members? Should it be your office? Should it be somebody else?
I mean, I'm a little biased, but yeah, I would say our office does frequently review for pretty much all of the professional and social fraternities. We do. I personally don't do a lot of that work, but we do have 2 girls in our office that are constantly reviewing other organizations' documents, and so we're happy to do that. The point about should members be doing it, that gets very dicey. We've got another organization that their members just decided that they wanted to go. It is a sorority. They decided they wanted to go entirely gender neutral, and the national office and the board is like, wait a second, this kind of flies in complete opposite direction of what our whole existence is. We're a sisterhood. We're not going to be a siblinghood. And so it can get a little convoluted, but you should have some mechanism that members feel that they can voice concerns at any time if necessary. So that might be a kind of a happy medium, that if you have a suggestion box or comment box, virtually, of course, that members can raise concerns or ideas that they have, and then those can be taken into consideration. But in terms of reviewing your fundamental documents, I think that's more just a legal thing, mostly to make sure that you're up to date on the law, and again, to make sure that your actual practices match what's being said. We do see some organizations that, as they grow and develop and expand, their their original tax exempt purpose is not what they're actually doing anymore. I don't foresee PAD's purpose and activities changing drastically like that in the future. But again, if you have some sort of conflict of interest policy, or you say we're suddenly going to change the term limits for our board members, you need to make sure that your policies match what you're actually doing operationally.
Thank you, Ilana. We do really appreciate what you and Fraternal Law Partners provides Phi Alpha Delta. I thought this was a great presentation for all of us to hear the basics and a little drill down to make everybody feel a little bit more comfortable about what it means to have all these duties.
Yeah, absolutely. And if you guys have any questions or concerns, you can email me directly, or you can go through Andrew. I'm always happy to help, especially an organization like PAD out. All right. Thanks, guys. Enjoy the rest of your conference.
Thanks, Ilana. Really appreciate it.
No problem. Bye.